Welcome out this week to A Case for America. I am Austin Hepworth, here with Michael Hepworth, and we are here to talk about more of the Constitution, the Fifth Amendment in particular. And as a reminder, we do approach America and the Constitution from the perspective of it being a balance. That to us, the state of liberty is a condition created by law, but also created by morality. So when you have anarchy on one side and tyranny on the other side, you need laws to pull you out of anarchy, but you need personal responsibility and morality to keep you from tyranny. And liberty is the point at which the law and morality strikes the necessary balance. If we get off on that balance, then we start shifting towards anarchy or tyranny and losing our state of freedom. So today, in talking about the Fifth Amendment of the U.S. Constitution, we wanted to focus on the first three rights granted in there. There's a total of 5 rights, but we'll focus on the first 3 today. But the text of it says, "No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger." So that's one right associated with the grand jury. The second right is, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb." So that one's called the double jeopardy clause, and is the second right we'll talk about in the Fifth Amendment. The third right says, "Nor shall be compelled in any criminal case to be a witness against himself." And so that's the right to remain silent. One of the probably the most famous constitutional rights. We see it on TV a lot. You have the right to remain silent. That comes to us from the Fifth Amendment. So in looking at these today, it's probably helpful to go through a little bit of the some of the terminology and to understand a little bit of what's happening, because the Fifth Amendment does get a little complicated. There are a lot of exceptions, differences in what's taking place. So the first right we're talking about, grand jury, when we are talking about a capital or otherwise infamous crime. Those are the 2 crimes that require a grand jury be involved. So first, what's a grand jury? A grand jury is a selection of individuals from America. It's American citizens that are called in. And they have the power to investigate crimes. They have the power to issue subpoenas. They have the power to question witnesses. And they're brought together by a prosecutor, a federal prosecutor, that calls for this grand jury to be convened. But ultimately, the grand jury decides whether they're going to issue a formal indictment or not. And so what this serves as is a check and balance against the government's police power, their ability to bring criminal charges against you, where a government official or government employee can't just decide on their own to bring criminal charges against a person. They have to seek to satisfy a body of jurors that there is enough information involved or enough evidence involved to bring the charges. So this applies at the federal level, and this right applies to the capital or otherwise infamous crimes. Capital crime is generally one where someone could have the death penalty imposed on them, and then a infamous crime has been held by the Supreme Court to be something that means you can go to jail for 6 months or more, or you're fined more than $1,000 or so. So typically this is kind of shook out to be where if there's a felony charge brought against you, they typically will require a grand jury. If it's a misdemeanor charge that has a lower jail sentence or lower fine associated with it, then they might not require a grand jury to be involved at the federal level. And so depending on the severity of the crime will depend on whether a grand jury is required or not. And again, basically all felonies are going to require a grand jury in the current American system. And so there will be ultimately if a criminal is convicted in federal law, there will be two juries that reviewed the scenario. There'll be the first jury that issued the indictment, and then the second jury that sat in and listened to the facts and circumstances of the case. But one other important thing to note about the federal grand jury is that there are many criminal charges that are brought, even felony charges, that are brought at the state level without using a grand jury. And the state prosecutors in many states have the ability to file charges without there being a grand jury involved. And the Supreme Court over the years has had to look and decide what rights it will or won't extend to the states. Because you have to remember that the Bill of Rights, the Constitution, the US Constitution, only applied to the federal government. And so its prohibitions and rights were restrictions on the federal government. So if you fast forward to after the Civil War, when there were quite a few things that had taken place in America, and the states were they passed new amendments, 13th, 14th, and 15th Amendments, dealing with getting rid of slavery, trying to bring in some equal protection. And by this time, America had seen states perpetuate quite a few abuses on citizens of those states. So slavery had certainly been one of those. But even then, there had been other abuses, such as when the members of the Church of Jesus Christ of Latter-day Saints were expelled from Missouri. They had an extermination order issued by a state against them, but the rights of religion associated with their rights to worship didn't fully apply because this was done at a time when the 14th Amendment didn't exist. And the First Amendment only stopped the federal government from doing that, but the states would still take actions. So there were quite a few discriminatory actions taken by states. So when the 14th Amendment came around after the Civil War, one of the lines in it says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. So the due process clause, which we'll look at more next time, was expressly extended to the states. Again, the Fifth Amendment said it was Congress. 14th Amendment says due process restricts the states too. And then it says, nor deny to any person within its jurisdiction the equal protection of the laws. And so the Supreme Court had cases come up that said, hey, because this 14th Amendment that says no state can make or enforce any law which abridges the privileges or immunities of citizens of the United States, they said the Bill of Rights gives us privileges and immunities. You can't take those away from us. And the Supreme Court said, we don't agree that all of the Bill of Rights apply to the states as a result of this. We think that some of them will, but not all of them. And so the Supreme Court started on a journey, case-by-case journey, to look at and determine what rights in the Bill of Rights applied to the states now because of the 14th Amendment, and which ones didn't, which ones were still just the federal government. And the grand jury was one of those that was not extended to the states. The Supreme Court looked at it and said, yeah, this isn't one of the privileges or immunities that's being talked about. And so states can continue to do criminal trials, criminal charges, however they want. That's different from the next two rights, which the double jeopardy clause, which says you can't be twice put in jeopardy for same charges, same offense, essentially. That was applied to the states, as well as the right to not testify against yourself in a criminal trial. And so we got this situation in America where part of the Fifth Amendment applies to the federal government and the states, and some parts only apply to the federal government. And it's always interesting. If you want to look more at the court's reasoning, you can certainly go into the history of that. There's places that talk about that. You can look up selective incorporation of the Bill of Rights to go through that. But I think for our purpose, with the case for America, we want to look at, do these rights and privileges granted in the Constitution provide a proper balance? Is there enough law there? Are there checks and balances there? Or are there problems with it? Do we want to take people's time to go through a grand jury? Is there value in that? And to look at some of the opposite side to say, well, what happens if we don't have the grand jury? What happens, what could happen? Some of it may be hypothesizing, but some of it could be looking at history. Some of it could be looking at states without a grand jury. And one of the things that I wanted to bring up today, because this is actually an area where I personally feel that we're out of balance. And that's with the state ability to bring criminal charges against people. States can put people in jail for their whole life, and they can bring charges against people. And if you're in a situation where government comes after you and they charge you with crimes and you have to find the money to pay for an attorney or get a public defender who are often overworked and stretched pretty thin, what do you do in that situation? Do you plead guilty just to try and get a plea deal? Because the risks are very high. If you're found guilty of something, then what happens to you? And to give an example of a scenario, the Duke lacrosse team a number of years ago was, I think they were the top lacrosse team in the nation. And they had a team party. And after the party, there was an accusation that surfaced that the team had gang raped a lady. And the prosecutor looked at the evidence, and it was pretty clear that the charges were completely false, that the claims were completely false. They'd been made up. And despite this, the prosecutor, I don't know if the prosecutor wanted publicity, what was going on, but they could show that the prosecutor knew it was false, lacked merit, but the prosecutor filed criminal charges against all the team members anyways. It went all over the national news. These team players were kicked off their team, had all kinds of issues and fallout associated with it. And in the end, it was shown to be false. It was shown to be, just for whatever reason, false claims, and this prosecutor coming down and filing charges against these young men. But all of that took years to work itself out, and there was incredible collateral damage along the way. And so we're at a spot where this team, they sue the prosecutor. They said, hey, this is malicious prosecution. This is misconduct. And so far, the Supreme Court, the U.S. Supreme Court, has been very, very, very opposed to introducing any liability against prosecutors for abusing their positions of power. And so we have scenarios where prosecutors have a constitutional duty to disclose evidence that may prove you didn't do something. So one of the things that started happening in America was they were finding out the prosecutors had evidence that proved that the person wasn't guilty, but they would still prosecute them. So they could say that we solved the crime or get the attention or whatever it was, I don't know. But they wouldn't turn over the evidence to the defense team. And so there became a rule that the prosecution had to produce all the evidence, even if it disproved the prosecution's case. And there would be situations where, even with that affirmative duty in place, the prosecution wouldn't disclose that information. And there was a time when the prosecution actually took a case through and let a guy get put on death row when they had evidence in their possession that showed he didn't do the crime. But they were so motivated to get a conviction, motivated to, solve the issue or crime, that they knowingly tried an innocent man, put him in jail. And it wasn't until a few weeks before his conviction was scheduled, after many, many years in jail, that some team working on things found some obscure file in this police courthouse from decades ago and was able to show what had happened. They got the guy out of jail. He didn't actually die, but still he served decades of his life there. And they sued for prosecutorial misconduct. And they were still barred from recovering against this prosecutor. And the Supreme Court said, we can't put any liability on prosecutors because they need the full range to do their job vigorously to prosecute things. But I look at the police. We sue the police all the time in our society. And I think arguably it's made the police force much better. And I would say I do feel there are too many lawsuits currently over too many things. And they were starting to put an impossible standard on police. And I do think there's serious issues where we're getting out of balance. But I do believe that some lawsuits for certain types of abuses are very important against all government officials. If you abuse your authority as a government official, I don't think you should have immunity from a lawsuit necessarily. There's certainly situations where it's questionable, situations where some decision has to be made and maybe hindsight later proves it to be a problem. But I'm not talking about those situations. I'm talking about just clear, complete disregard for the rules. You have the power, you just steamroll past all those. And on the prosecutorial misconduct side, the prosecutors have an extreme amount of bargaining power with people. They can bring charges, and again, what do? You're faced with a battle, potentially years-long battle, faced with the stress of court, the cost, all those expenses. Just the defense cost alone is extremely high. Very few Americans can afford to hire a criminal defense attorney that goes all the way through a very big case or big trial. And it's a serious power that there's not really a check on currently. And so to me, one of the ways to help restore that balance, if the Supreme Court's fully opposed to any liability against prosecutors, might be to extend the grand jury requirement to all states so that a jury touches it at the beginning and end, where they can't bring charges against someone unless they've got really good evidence. And the grand jury can look at things, review things as well, and make that decision independently. So that's one right talked about here. You will hear there's a lot of proceedings against President Trump going on right now. There are grand juries that have issued things there. Those are federal cases, federal crimes. And so those are individuals that looked at those first and opted to formally approve those charges to come. To me, the grand jury is a fairly good check and balance on the government. It's one I'm a fan of. And I do believe that states would be better. There'd be less abuses if there was a grand jury requirement for the states as well. And so that's one in the balance side of things that I would really articulate and suggest that maybe anyone listening or anyone interested in this start to push that type of changes to a lot of the systems.
And I think you highlighted a couple key points that we should focus on when we're discussing American law and how we're trying to move forward. One of them being we have the Constitution that is a set of laws set up for the federal government. I don't know that we clearly understand that in our conversations today, that it's a list of powers granted to the federal government. And so it doesn't necessarily apply to the states unless it's listed as being that way. And the way many times those constitutional laws are applied to states is through the Supreme Court. I think, as you mentioned, Supreme Court has been deciding kind of what parts of the Fifth Amendment are applicable to the states and what parts have not been. And that's through the Supreme Court cases. They get appealed up through to the Supreme Court. If you've heard of your Miranda rights when you maybe are arrested at a state level, that's dealing with a Supreme Court ruling in a case, Miranda versus Arizona, I believe it was. And that's how the Supreme Court kind of will push constitutional law down to states many times. But it's not the only way. As you said, if we discuss what part of the Constitution maybe should be applicable to the states that the Supreme Court hasn't, there are opportunities for laws to be made either at a state level or a federal level. So we could start saying something like, well, maybe we need to have a grand jury down at the state level. And this is something that should be applied at the state And I think as we have those discussions, the other piece is we need to talk about what the principle is. Why are we trying? What are we trying to do? What was the balance we're trying to bring into being? There seems to be a lot of power on the prosecutorial side to come to a citizen and say, you're accused of something. And the citizen has difficulty fighting back against that. And the Fifth Amendment seems to indicate the idea of not being deprived of, well, we're getting to the next part of the Fifth Amendment. We won't get into it yet, but being deprived of life, liberty, or property without due process of law. Some people like to call that, being, you need to be, you're innocent until proven guilty. And there seems to be this balance of power shift where there's a lot of ease to accuse somebody of something that can really hurt their lives for a very long period of time. And it's a very difficult process for an individual to fight back against that. And so is there, in pursuant of the principle of individual liberty and trying to help people stay free, what aspects of the Constitution can we take from a federal level and apply to state or more local level?
Yeah, and those are great principles to raise. And I think maybe even just to try and help it feel a little more relevant, we have a lot of allegations that fly in our society today about sexual harassment. And there are certainly, unfortunately, a lot of situations of actual sexual harassment that occur. But there are times where there are false allegations made. And this is a situation where if we live in a country where it's just, oh, someone accused me of something, therefore I lose my job, I lose my rights, I lose all these things, and I have to battle for 4 years to try and prove my innocence. What does it matter at the end of 4 years? You're already dragged through the mud. You're already names destroyed. The news has moved on. All those things. You've lost your job. All that's taken place, and there was no check or balance in whether those charges were brought in the first place. And so what it does is it makes it so that individual citizens, if you ever offend somebody or get upset and they make up a charge against you, they can do a lot of damage to you in a system like that. And it's one I think that people are starting to recognize is there's danger in the power of an accusation because we can't trust everyone to be honest. It's a sad state of affairs, but we can't trust everybody to be honest. And it is a crime to sexually harass someone or molest them or touch them. And I've worked with a fair number of people in my time as an attorney that have been accused of some type of sexual misconduct who I believe were completely innocent. They maintained their complete innocence the entire time. And it's interesting to look at the scenarios where, and even to realize that some of the situations there could have been actual harassment or abuse that took place, but sometimes the people didn't always know what scenario it was or wasn't, or meaning they didn't know who the perpetrator actually was. There were times if someone's groped from behind, for example, that the person may be in a crowd and they have a guess about who it was, but they don't know for sure. And so it's possible that the accuser isn't even lying necessarily, but they don't always have correct information to talk about with it. And so in these scenarios where people are accused of things, they always ask, why do I have to go through and try and proclaim my innocence? Isn't this backwards to America where they're supposed to put the evidence in against me, show it was actually me there? And they don't have those, but they have these accusation. And again, in these scenarios, it's a very heavy situation to be in. If you're going into a situation where someone says, yeah, he did this, she did this, and there's not a lot of evidence either way, what do you do in those scenarios? And again, it just starts to create an incentive when an accusation can be leveled and the prosecution can just bring whatever charge they want, where you really have to toe the line and stay in the good graces of society, or else people can bring out whatever claims they want against you.
And hopefully not to get it off topic, but maybe to highlight the other side of that balance. At some point, we kind of have to ask ourselves, what can we reasonably expect from the rule of law? Can we be able to seek redress for every single thing that we're wronged in? Is that even within the capacity of a government? Is there something we need to be focusing on as a society to try to build safer societies? Obviously, I think we all agree that we need a rule of law to seek redress when there are wrongs, but you can't always prove something. Situations are tough. What can we do as a society? I guess I'm asking both sides of the question here. What do we do as a society to build up a safe and a healthy environment for everyone? And what do we do on the governmental side to make sure that we have the proper rights to pursue individuals that have taken inappropriate actions, that we protect people who are falsely accused? There needs to be that balance of what are we doing legally and what are we doing in our communities? Are we trying to build strong communities, or are we just saying no, all responsibility for wrongdoing is going to be placed on the shoulders of government and we're going to try to let them sort it out? I'm afraid we'll get really heavy-handed at that point, and there's probably some sort of balance we need to strike between the two.
Yeah, and it's a great point. Really appreciate you bringing up the other side and talking about the balance too, because it's very true that one of the main things that discourage victims of sexual abuse from prosecuting it or pursuing justice with it is how exhausting and tiring the process is. We're very heavy-handed in providing rights to the accused, which again there's a basis for, but it is one that what do we need to do as a society to try and make this process appropriately balanced, where we're not just saying, oh yeah, you've got to be a marathon runner to go the distance in pursuing justice in this situation, because there are bad things that happen, very inappropriate, very wrong things that happen, not just in the sexual abuse realm, but throughout society. And how do we strike the appropriate balance? And what are things we can do morally? Are there things we can improve in our society to help with that? And one of them to me is we often have this thing about, we don't confront people, let the police do that, all that kind of stuff. And I've often wondered, at least it seems that when I was a kid, there was a lot more of, hey, you touch my sister, I'll beat you up kind of thing. There was a lot more societal protection in place against certain things. And I've wondered if there is some level of societal protection that we could authorize or allow without fear of people getting sued. This isn't to say just to start a wild, wild west, just shooting guns and all kinds of things. But I do believe that morally we have some duty to protect each other. And if there is someone that's weaker or being abused, is there a way that we could, as a society, authorize people to take moral action and do something about that? I believe there is. We're already kind of doing that with things like mandatory reporting of child abuse. But to me, that's a little bit off balance still, where we're trying to get more people involved, trying to get a moral to become a legal obligation. And anytime, if you look at the balance scale of liberty being balanced between anarchy and tyranny, if we mandate the morality side by law, if we're mandating morality by law, that's approaching tyranny. That's always approaching tyranny when we have to start to mandate an affirmative. I'm talking about an affirmative thing. Like there's a morality that says thou shalt not kill. And we say, yep, don't kill, that's a law. That's different, saying don't do something, than it is to say, oh, you have a duty to jump in and do something. When we're mandating that kind of positive morality, when you have to step in and do something, we're really, in my belief, approaching the wrong way. And it's not to say that we shouldn't protect children. In my belief, the laws should allow for reporting of child abuse, but not mandate it. And it should allow for individuals to do certain things without fear of getting sued or in trouble. But if we mandate that you have to report, we start to produce a whole host of other problems and scenarios where, well, what if the person's abusive? What if the wife's afraid of getting killed if she reports the husband? There's no way that we can put these restraints on people. And we do have situations where spouses are being prosecuted for not reporting the child abuse of a boyfriend or others. But there's incredible difficulty to sorting through what's really going on in those relationships. And to say that we prosecute someone for not reporting child abuse is, well, if the child is getting abused in the home, there's a decent chance that the spouse could be abused as well if they report things or say things. And so to me, this is a scenario where it is very necessary to look at, are we out of balance? And I do believe, I will say, the Constitution guarantees the right to a speedy trial. That's in the Sixth Amendment that we'll get to. But I think it actually plays into this discussion because we look at that as only applying to the rights of a criminal. We're saying, oh, the criminal has to have the speedy trial. I actually personally believe that the victim has a right to a speedy trial as well, because then you don't have to live with it for 4 years hanging over your head. And I don't believe that in that balance, my personal feel is that right now we allow the criminal defendant to waive the right to a speedy trial and drag things out for however long. But I believe that right should only be able to be waived if the victim and the criminal defendant both waive that right. Because I think the right to a speedy trial is very much meant to protect the victim as well. Get him redressed quickly, get things through the courts quickly. I don't believe the founders were okay with a system where cases took 2, 3, 4 years to be done just for the trial, and then it goes up on appeal, and then it does all these other things. And I am a big fan of really working to push cases through court faster, to say, once things happen, we get our ducks in a row, we go have our trial, and let the evidence fall where it may, put it in front of these juries and things, but don't drag it out. Because if someone could get relief that's either charged with a crime or been a victim of something within 3 months or 6 months, that's a very different scenario than taking 3, 4 years to bring justice to either side, either the falsely accused or those that were actually wronged. So I think those are some great points. And like you say, at the state level, we don't have to go try and amend the US Constitution necessarily. We just have to go to our state and say, hey, let's introduce this right. Let's get the grand jury here. We need a check and balance in place. Or let's make it so the victim also has to agree to waive the right to a speedy trial. And I think that would really, really change this balance and make it far more likely for victims of sexual abuse to come forward and say things when they have to go for 3 months or for 6 months instead of, I've got to stay with this for 3, 4 years and relive it for that long. It's a very different scenario. So great points to talk about. I think some important things to look at for sure. So moving on to the double jeopardy clause. This is one I have a little bit of heartburn with how the double jeopardy clause has been interpreted by the courts. Currently, you can be tried for the same thing more than once, and you can be prosecuted, for example, by the federal government as well as by the state government. So there can be at least 2 of those. And then you can also be sued in a civil lawsuit where people are looking for money from you. And so you can literally go to trial over the same thing 3 times. You can have your federal trial, you can have your state trial, and you can have your civil trial. I should say federal criminal, state criminal, and then state civil, and potentially even federal civil, based on what the laws allow or don't allow. And the Supreme Court, in looking at it, said, yeah, it's could be argued to be being tried twice for the same thing, but we have two different sovereigns involved. We have the federal government with the state government, both get their shot at enforcing their laws, and each law technically produces a different violation. They said a different offense. So they said you're not being put in jeopardy twice for the same offense because it's a different law. But the law covers the exact same conduct. So to me, the double jeopardy clause has been fudged some. And I do think there is, again, a pretty heavy hand where you can have quite a few prosecutions brought against you from a number of jurisdictions for the same conduct or situation. And it gives the prosecutors a chance where either the state or feds go first, and then they can watch and see what went right or wrong, and then call in the same witnesses, change their tune some, not change their tune to the witnesses, but change how the prosecutor goes about things, their arguments. They can fine tune it and try and secure a conviction on the second go round. And so it's one where I don't think this is true to the spirit of what the founders intended here. But again, maybe it is because it only barred the federal government. It didn't bar the state government at the time. But I think, Michael, there's a number of, well, I guess this goes into another right, an ancillary right here. The double jeopardy clause, one of the things that it does, and then one of the things the courts have been very firm on, is if a jury acquits, meaning the jury finds you not guilty, that the government can't really appeal that. And that leads us to a place of, from the double jeopardy perspective, one of the rights that the double jeopardy clause gives is this right to what's called jury nullification, where the jury can just say, we don't care what the law is. We don't like this law at all. We're just going to say the guy's not guilty. And if they all say he's not guilty, even if he's technically guilty under the law, but they found it to be an unjust law, the government can appeal that. And I believe, Michael, there's a number of state constitutions that expressly reference the right to jury nullification in their state constitution.
Yep, that's right. There's, I believe, 24 that specifically call it out. They say things like, this is from the Constitution of Maryland, but I'm finding most of them are mostly the same. In the trial of all criminal cases, the jury shall be the judges of law as well as of fact. That gives the jury the right, as you say, to, in the end, say, well, we're going to judge this law as improper, so we're going to say that this individual is not guilty. That extends. Other states have it explicitly stated for freedom of speech. So like with respect to libel cases. For example, in Utah, it says, in all indictments for libel, the jury shall have the right to determine the law and the facts. So there's a large number of states that have incorporated this idea of jury nullification into their constitution. They feel that it's important. Yeah, I guess as we would call it another check on the lawmaking body of the government. Say this law is improper. As the people, we don't agree with it, and so we'll just say this individual is not guilty.
Yeah, and it is interesting, I think, to look the number of states that expressly reference it. Again, it's one that exists whether the state expressly references it or not, because the government can't appeal an acquittal from a jury. And again, there's always exceptions to things, so don't take something here as being the gospel truth for everything. There are a couple situations where they may be able to appeal an acquittal if there was defense misconduct or some other situations, but in general, it's very rigid that you can't appeal an acquittal from a jury. And so juries have this important check to say, we really don't like this law. We don't feel it's just, and it can apply across the board for however someone feels. If someone's prosecuted for drug offenses and the jury feels, you know what, we really don't like this law. We don't like throwing someone in jail for 25 years for carrying an ounce of marijuana or whatever they have. The jury can say no and just not guilty. And likewise, if it's a case, for example, with the New Mexico governor, one of the things she's done recently is to make it a crime to carry a handgun in a public space. She's citing a public health crisis of people being shot. But if a jury gets that case, if it went all the way to trial and someone was accused of it, the jury could just say, no, we don't agree with this. We're just going to say not guilty. And the jury has that power, case by case, person by person, situation by situation, to look at that. And it's a very fascinating check and balance that exists, a very powerful one. But it's also interesting, I've noticed recently that judges really haven't liked the jury nullification power. There's probably some judges that are fine with it, but it seems that in general, courts really don't like it. They don't like the prosecution or the defense to bring it up and talk about it. And they recently have started calling, some of them have started calling it jury misconduct, to go against and hold that someone's not guilty of violating a law. And I think that's very wrong for the judges to label it jury misconduct. It's not misconduct at all for the jury to stick this moral balance in there. It's one of the things the jury system was set up to do. If you go back to the balance, the anarchy on one side, tyranny on the other, liberty in the middle, it's law on one side balanced by morality on the other. And the jury has that province to balance all actions with morality, even to outweigh the law. And it's one of the reasons why I even say, I'll say it a number of times, the Constitution says it's the supreme law of the land, but it's not entirely true. Morality will supersede the Constitution at times. That does happen, where morality is the governing law and the governing force. And jury nullification with the double jeopardy clause is a place where morality can balance out the law, where it can supersede things. Even judges at times will determine that, yeah, this is technically a violation of the Constitution, but because the government has such a moral or compelling interest in this, we'll let them do it because they're giving a nod to, ooh, the moral justification is so high, we're going to override the Constitution. And so to me, morality is very much the governing law in the land. And it is one that we as a people have to maintain. But it is one that jury nullification really helps to reinforce this concept that ultimately our laws have to be moral in nature to be enforced. If they're not, the jury can just say, so what? Throw them out because they're not moral.
And that highlights that side where what do we do as a society to keep our moral values high? We can't legislate morality. That's, again, we get back into tyranny as we start telling people what their duties are. So what can we do as a society? I think we need to ask ourselves that question, start at a very local level. What are we doing every day? What are we doing with people around us to try to maintain high levels of morality? There's a lot of kind of out of the idea of we need to let people be free. It's let people do their own thing. And maybe we only complain about it online. But I think we need to stand, for what our values are. We need to let people know what we believe, not in a sense of condemnation, but there should be voices out there saying, this is my moral stance and this is why I believe. This is part of how we maintain high moral values in a society. If we just keep it to ourselves and just argue online, it just kind of turns into just kind of chaotic, and it lets the loudest voices kind of win over. And so, we need to ask ourselves that question. We're fighting for rights at the governmental level. What do we do to continue to maintain that balance in society? How do we maintain a high level of morality? I think it's an important question. And I don't know that there's one general answer, but I certainly think individually we can do things every day to help maintain high standards of morality in this country.
Yeah, very much so. And I love that you point out talking about it, because Morality won't stay alive if we don't talk about it. Morality is only given life by, to me, two things. One is talking about it, and the other is living it. Our actions actually have to embrace it and adopt it. So we have to choose to do things that may be uncomfortable or may require a sacrifice of us in order to say it's better that we keep it at the individual level. And if our actions can coincide with our words, where we explain our actions to people, we say, you know what? I didn't watch that movie, Hollywood, because you put in some things that were morally unacceptable. And if Hollywood can look and see that I didn't watch it and others didn't watch it, and we articulate that, things start to change. And if you look at, it's interesting, I was just reading about the Bud Light type disputes where Bud Light's being canceled for their ads, and there's been attempts to cancel Target, Chick-fil-A. People are opposed to Chick-fil-A because of their messaging. And it was interesting, at least in the one article I read, they felt that the Bud Light boycott had been the most successful so far because it was easily replaceable by Americans. It didn't require any real sacrifice for an American to switch from one cheap beer to another cheap beer. Very little difference in taste. And there were so many other beers readily plentiful that they could just jump from one to the other, no big deal. But when it comes to an American replacing Target, it's a lot more difficult to do. And so the Target boycotts or backlash, while they have produced some impact to Target, none of it's been sustaining like it was with Bud Light. Same with Chick-fil-A. People might boycott them for a day, but apparently their food's good enough that people don't find a suitable replacement elsewhere. And even those opposed to Chick-fil-A will still shop there. And so it gets to this point where, and I'm not here advocating that we should or shouldn't boycott companies. It's more just to talk about this principle of morality, that if we say, oh, we don't like Chick-fil-A, but we're not willing to not shop there, then our words only go so far. But if our actions, like with Bud Light, and our words say we don't like what you did, it carries a lot more weight and a lot more impact. And there's then this moral thing that starts to take place where companies and others say, ooh, there's a moral outgrowth from this where words and actions align. But if just suddenly, let's just say Bud Light just suddenly lost sales, they had no idea why, no one ever spoke up about it, it also wouldn't be super effective in the moral realm because the two didn't align. But to me, the point of that is to realize as an American that when something happens that's morally wrong, we have a duty to do something, even if it's at an inconvenience to us or it's not ideal. And we have to live true to that. And we can't just tell a company, oh, we don't like what you did, but I'll still buy your stuff. Before we speak up, we should say, do I have enough of an issue with what they did or didn't do to stop using them? And then we have the moral responsibility to figure out a replacement to it. But that is how morality lives. That's how it's enforced, is that we as people have to say and do things. And even just to give an example, my daughter was a little frustrated. We were at church and her and one of my younger sons were doing something with their hands. She didn't feel it was noisy, but someone behind her said, shh, tapped her on the shoulder and said, shh. And she didn't like that at all. But I kind of liked it in the sense of I didn't notice it. So they were far enough away from me, I guess, that I couldn't hear it. But morality is something that we have to help teach people to share. Hey, this is impacting me, making too much noise for me. And there's certainly nicer ways and meaner ways to do things. and we have to be sure to be civil and be appropriate in that. But we have to be willing to speak up. We have to be willing to share with people. Actually, that is a problem. I don't appreciate that. I don't appreciate what's taking place. And again, we're off on a little tangent currently from the Fifth Amendment, but I think it coincides in the sense of we're talking about morality and enforcing morality. Juries are one way to do it. But we are, as the people, we're ultimately vested with this power. That's why we as the people have the ultimate governing ability in America, because everything in America comes back to this morality check and balance. And when we go silent, morality loses its life. It starts to die out. And we have to speak up. We have to share with people why we believe what we believe, why certain things are important. Even looking at things like, again, a little bit tangential, but the Senate recently voted to change its rules of its dress code rules, essentially, to allow people to wear hoodies and other things there. I think that's crazy wrong. We're here talking about one of the most important functions in America. You're representing people, hundreds of thousands of people. Wear a suit, wear some clothes, show respect for the position, show respect for what you're doing in America. And I believe very strongly that we should speak up and say, no, Senate, wear appropriate attire, be there. Because that is a moral thing that conveys a lot. And again, it's a tangent to this Fifth Amendment side, but it is something that we need to do to maintain our morality in America. And the Fifth Amendment, I believe, has an incredible amount interwoven with morality associated with it.
Well, and to your point, the Fifth Amendment is, one important aspect of maintaining our rights and our morality. But if we forget it's government by the people, all the judges, all the lawmakers were put in place by us. They came from the people. And if our society has lost its moral compass, then those we elect, how can we expect them to have a moral compass? And so it really does need to start with us. What we determine to do in our everyday lives is going to have those downstream effects of what's going to be determined by a Senate, by a judge. And so there's that two-part balance. People need to maintain their morality. We need to stand up. Even if I know people like to, we talked about the Senate dress code, people like to be comfortable. And life in America is getting very comfortable. Dress standards are being very relaxed. You don't need to dress up for almost anything anymore. What are the downstream effects of that? Do we start to take lawmaking in the Senate lightly, and it's just relaxed and it's not an important aspect anymore? Do we have, our own actions to look to try to decide how do we get to this point? Well, maybe we wanted to be too comfortable too often. We didn't take our own personal lives seriously enough. Just questions we can ask ourselves every day. How do we maintain morality in society so that those we elect will also seek to maintain that same morality, and we can fight this balance from both sides?
Yeah. And I look at the Fifth Amendment as a great place to talk about these issues. But again, the case for America as a whole, it is a balance. And we can't pretend like changes to Senate dress code don't carry significant implications to it. We are, one of the things to even know, we are human. We often talk about the government as if it's some non-human thing that's out there just doing something. Every government official is a human. And if I just show up to court in my shorts and I got khaki shorts and flip-flops on, and I'm here to put you in jail for the rest of your life. But hey, hang loose, whatever. No big deal. We'll just shoot the breeze. Well, there's a lot at stake, and I think that there's a ton reflected in these things, and a ton of morality also. And so when we go to something like the Miranda rights, this third right that we're talking about today, the right to remain silent, it's an interesting thing because we have to, I think it's an interesting question to say, well, why do we need to remain silent? And one of the pieces is that the from the beginning, if you look at the history to kind of the cases leading up to the Miranda versus Arizona decision that you talked about, because the Constitution doesn't say the police have to tell you you have a right to remain silent. We talked about this in a previous podcast. And the Supreme Court ultimately came out and said, there's no way to really give this right fully unless the police tell you you have a right to remain silent. Now, if you remember, I argued that police should also tell us we have the right to say no when they ask us if they can search our things. I believe those two rights go hand in hand. And I do believe the police should have to inform you. You have the right to tell me no. You have the right to move on right now. I don't have the basis to keep you here. So that we can be fully informed of things. But at the individual level, leading up to the Miranda case, which was in, I think, 1968 or early 70s, sometime around there, we can confirm, but it's sometime 60s or 70s that this case took place. The courts had been very concerned with what they call coerced or involuntary statements, where the police would say, well, we're going to keep you here until you confess to us. Or, we're just going to keep whacking you with a stick until you confess. Pain, torture, other things that we often don't associate with America, but that really happen. If you look right now, they just ruled that one of the people from the 9/11 attacks that they're trying to put on trial, he's unfit to stand trial. He's crazy because of all the repeated CIA torture, where he was considered to be one of the people who helped design and orchestrate the attacks on the World Trade Center, the plane attacks that took place. CIA captures a bunch of guys, throw them in jail in Guantanamo Bay, which is in Cuba off of American soil. And they don't bring them to trial right away. No speedy trial. They actually torture them. It's documented, the torture is, the things that took place, because they allege they wanted to get more information from them. But these guys didn't give more info. They didn't get additional information about the attacks and what took place. And the guys just end up crazy. And so we still have a situation now where 21 years after 9/11, 22 years after 9/11, we don't have a trial of people who are alleged to take place with it. And it's a little wild to look at and go, so because they were held off American soil, we just circumvented these constitutional rights, we tortured people, we did these things. But the courts, over the years, torture took place consistently. Prisoners would get beat, this power abuse type thing. And the courts took a very strong eye against coerced statements. They wouldn't admit them in court because they felt they were inherently unreliable, even if you said them yourself about yourself. And then that led into the court saying, well, when you're in police custody and you don't feel you have anywhere to go, and the police say, we got you, so just tell us what happened. Or we got you, you better just admit you were a part of this, or else we're going to make it way worse for you. You're sitting there, you're in police custody, what do you do? And the Supreme Court took an eye to say, yeah, this is a problem. We're going to mandate that they tell you you have the right to remain silent. You don't have to listen to them. And this right kind of grew out of government abuses, government issues, where, yep, there were abuses, morality wasn't being followed, and the court was trying to rectify that. And so it imposed a condition that's not in the Constitution to try and help correct some of that. But it also created a ton of situations they didn't love. And so there are exceptions to the Miranda rights. There are exceptions to when the police have to tell you these things. And some countries, developed countries, are taking it the complete opposite way, where they just say, you know what, we're going to get rid of this whole perjury thing. And we're gonna make it so in a criminal case, it's no crime to lie. So witness, take the stand and say whatever you want to say. And you can never be prosecuted for lying. So tell any story you want to try and convince the jury you didn't do it. And I don't necessarily agree with that approach. But it is one where in America, if the defendant doesn't take the stand, we do often as a jury assume they must be guilty. It's a common thing that we start to assume about someone that's not on the stand and never testifies. And with these Fifth Amendment cases, one interesting scenario to bring up is to go back to the fairly famous or infamous O.J. Simpson trial. He highlights a number of these things. O.J. Simpson was sued criminally and found not guilty, but he was sued civilly for the same thing and found to be liable for it and had to pay a bunch of money. So to me, again, starts to become a double jeopardy type issue. But with the charges brought against him, the thing that I feel really cinched the prosecution's loss in his criminal trial that made it so that O.J. Simpson was found not guilty by the jury was an interesting use of the Fifth Amendment. Because one of the things that courts have required that I'm not a fan of personally is they say that once you invoke your right to the Fifth Amendment, so once you say, I plead the Fifth, I'm not going to answer that question, you have to plead the Fifth for the rest of the questions. You can't selectively pick and choose which questions you don't answer and which ones you do. And so what happened in the OJ case is one of the detectives or police officers working on the case was brought to the stand by the prosecution, and they said, hey, are you racist? You know, O.J. Simpson was black, and they were making the case that it was just a racially motivated prosecution. And the police officer said, no, I'm not racist at all. And they said, oh, well, have you ever used, you know, these certain words? And they went through things like the N-word for black people and things and said, have you ever used these? And he said, no, I don't use those, not racist. And so then after they call him, they flew someone out to Carolinas somewhere, I think, East Coast somewhere, and obtained a tape from a radio station where this officer had been on a radio show and was very racist in the radio show, had a lot of racist commentary, used the N-word multiple times. They bring it back to the court. They give notice that they're calling him back up there, and they're going to hammer him for perjury, for lying. But before they do, rather than just introducing the tapes, they put him back on and they say, okay, they said, so you were here before, you testified that you weren't racist, you testified that, you know, that OJ, that you found this glove and that it was this evidence and that all these things were lined up the way it was. And they said, but have you ever lied under oath? And then his attorney whispers in his ear, and you can watch this tape. It's pretty fascinating to watch. Attorney whispers and said, oh, plead the Fifth, because they've got evidence against you. They're going to bring it up if you say something. So he says, well, I plead the Fifth. And then he's sitting there on the stand, but at this point, it's not just you get down. You have to keep pleading the Fifth to all the questions after that. So then the prosecution says, well, have you ever planted evidence on someone? Plead the Fifth. That's all he can do at that point is plead the Fifth. And so they just go through and then hammer his credibility to make it look like he planted evidence, to make it look like he came after OJ. And it was a very bad look in the case. But it's an interesting outgrowth of this right to remain silent, where the courts go, well, you have a right to remain silent, but you can't pick and choose when to be silent, when not to be. And again, it's probably one where I think the balance is off on that we should be allowed to plead the Fifth to certain questions, but still choose to talk about things that, you know, have been correct or whatnot, or that we feel is appropriate to talk about. But it's not one that the courts have granted that way. And so it leads to interesting conclusions like the O.J. Simpson case, where he's found not guilty in the criminal trial, guilty in the civil trial, but he doesn't go to jail for that particular crime at that time, pays money for it. But again, the right to remain silent is generally an important right, because we as people don't always know even what our own sayings will or won't mean. And there's so many laws, they're so complex, we don't know what's going to get us in trouble and what's not. And it's not to say that, that we should just be allowed to try and get out of everything. If we did something wrong, we did something wrong. But it's more to say, if the government comes in and says, oh, so you took money from this person. Yeah, they paid me. Oh, they paid you. So did you follow the employment laws on that? Were you registered as an employee? Probably not. They just gave me some money. You don't know. You're just trying to get into all kinds of trouble with whatever laws, and they get in the heavy hand of government with how many things it has. And maybe you were just doing some honest work, but you have no idea what kind of hole you're digging yourself into as you keep talking. And I do see that often, where people will keep talking and talking and talking and bring up all kinds of other issues that would have never been an issue, never been on the radar, if they didn't even know to not, to stop talking at that point. And to me, that's more an outgrowth of how disconnected our laws have become to the average citizens, where we just don't even know what gets us in trouble, what doesn't. And so most people understand, it might be wise to have an attorney present. And generally, it's so that you can talk to the attorney beforehand, get an idea of, can I say this? What's appropriate? Did I break a law? What's going on? And still, we often look at people as being criminals, but there's so many laws now, so many things that you can get in trouble for, that it's good people violate laws. It happens all the time. We've all, in America, I believe, violated a law, not because we're bad people, but just because something happened. We've sped, or we've not filed taxes correctly, or environmental laws. If you put oil down the drain, that's a criminal offense. There's all kinds of things that, talking about car oil, or if you dump it in your curb or gutter, that can be a criminal offense in many places because it goes into the storm drains. And there's just so many aspects to life that happen that it's not always possible to track it, to keep it. And so again, the right to remain silent is just this right of saying, you can't torture me, you can't coerce me, you can't pressure me into things. Make sure there's evidence that lines up, because otherwise people will crack, people will break, they'll say things. We have huge history of people confessing to things they didn't do because of the pressure on them. And it's one where we're being protected against our own weaknesses, in a sense of heavy hand of government can't come down and say, you got to talk, Austin. But all interesting rights that they felt necessary to spell out. They'd seen these injustices before. And it's ones that I believe we have a duty to uphold to help keep the balance in place. But Michael, like you talk about, to really push for the moral balance in a lot of these. There is a lot of balancing to do. And it's something that we, as Americans, can continue to strive for, to keep America this amazing place to be, where freedom is operating at its optimal levels. And so we appreciate you being with us today. We will be focusing on due process next time. And then we will also, whether it's next time or the time after, talking about eminent domain and the government's ability to take property. It's turning into a more interesting scenario. There's a lot of situations coming up there with the BLM, the Bureau of Land Management, with declaring national monuments, with all different kinds of things taking place. There's quite a bit to talk about. So we appreciate you guys being here, and we look forward to talking with you more next week. Thanks so much.